All right, so joining us on the show to discuss more is the Senior Advocate of Nigeria, SAN, and the President of the Nigerian Bar Association, Yakubu Maikyau. Thank you for joining us, sir.
Thank you very much for having me.
Yes. So one of the reasons why we brought you on is to discuss all the various issues concerning the legal profession in Nigeria, the issues concerning stalled cases, the corruption many have accused various lawyers of, and so many more. But first, before we go into that, we'd like to hear your thoughts on our hot topic, the young lady Ifunanya Grant, who NBA had accused her of posting unclad photos of herself, nudity and all, and being a lawyer, the young lady who was called to bar. What are your thoughts on that? And we had a conversation concerning the fact that, yes, people have their private lives, but how do we understand, or how do we help them to navigate the privacy of their lives and their professional lives?
Well, thank you very much.
Go ahead, sir.
Yes. So thank you very much. I understand the hot topic that you're talking about has to do with the alleged act of professional misconduct by one of our colleagues. As you've already noted, the Nigerian Bar Association has taken a decision. The National Executive Committee of the Nigerian Bar Association has taken a decision to make a report of that conduct of our colleague before the Legal Practitioners Disciplinary Committee. And because we have done that, the Nigerian Bar Association cannot be a judge in its own cause. So I cannot comment on it. I have my thoughts, no doubt, but because this has been subjected to professional scrutiny, that is to say, the body set up by law to examine the conduct of lawyers and pitch it side by side with the rules of professional conduct and determine whether or not it was proper for the lawyer to have conducted himself or herself in that particular manner. I must refrain from making any comments on it.
All right.
Okay, sir, I want to specifically ask a question because while we were discussing or trying to understand this, a few questions came up in our minds regarding if it is against, when you get signed, when you get called to bar, is it against the ethics of the legal practice? How is dressing or indecent dressing, inappropriate dressing, something that is against the legal practice? Like we know for doctors, they sign this Hippocratic I don't know the word, oath. And when they sign that oath, the agreement is that they must not watch someone die. They have to do whatever it is in their power to protect life. Is there something like that regarding the legal practice and their dressing?
Personal life.
Generally, personal
yes,
life.
So the rules of professional conduct actually is particular about dressing. And we are taught even in the Nigerian law school that you have to be representative of your profession in the way you dress. The profession is a noble profession. You have to appear decent. You have to appear responsible. So yes, there is that clear demand on everyone that is called to the bar who has now come under the operation of the rules of professional conduct to make sure that he conducts himself honorably, he dresses decently and responsibly. Now, whether or not this particular case falls short of that standard, like I said, I cannot share that thought because I am a complainant against this lawyer on this alleged conduct, and I will leave it at that.
Okay, now let's go to the law profession in Nigeria. One of the things we discuss often on the show is how important the judiciary is. for us to actually have a sustained democracy. One of the issues we've had in Nigeria is that corruption cannot be totally defeated if our judicial system is not effective and people are not publicly convicted for the crimes they commit. One of the major issues that many would say the new AGF or even you would have to do right now is the fact that many cases are stalled for years for various reasons, technicalities, maybe they keep postponing the date. What do you think can be done to strengthen the current judicial system as it is today?
Well, thank you very much for that question. And let me make the point from the very onset that the responsibility of anyone that has been given the task to prosecute any criminal matter is not to achieve conviction at all costs. Because the prosecutor equally has the responsibility where he discovers in the course of his investigation that the person against whom a crime is alleged, there are facts that can help him in his defense. That prosecutor is under a duty to make those facts available to the defense for the defendant to use it for the purpose of his defense. So it's important to make it very clear that the objective is not to secure conviction. It is to pass through the process set by law for the purpose of determining the justice of that case at that particular time. And so, in that particular process, before the matter comes to court, a lot of things would have happened from the point of investigation, the collection of evidence, the advice that is given, and then the matter or the charge is filed before the court, and evidence is led by witnesses before the court. Now, the judge is under strict obligation to confine himself to the matters that are presented before the court. And when those facts are presented in terms of evidence, the responsibility of the court is to look at the nature of that offense, what are the ingredients of that particular offense, has the prosecution satisfied the ingredients of those of that particular offense, so that, and so it could be said that the offense has been proved beyond reasonable doubt, and only then can a pronouncement of conviction be made.
Okay.
So when the public sees the outcome of any proceedings from the court, the public must know that, number one, irrespective of what you know out there about what happened, the circumstances that led to the commission of that offense, it is only the things that are brought to the knowledge of the court in the case that will form the basis of the determination that the court would make one way or the other.
All right.
Great. So let's talk about financial autonomy. The judiciary literally depends on the executive for funding. So help us understand how this lack of financial autonomy is affecting transparency and the true independence of the judiciary.
Well, we all know we need resources to drive any process of governance. The legislature will need resources for it to function effectively and efficiently. The executive does also require resources for it to operate within the ambit of what the Constitution has prescribed for it to do. Similarly, the judiciary also requires resources for it to function within the ambit of what the Constitution has prescribed for the judiciary to do, in terms of the structures that have to be put in place, in terms of the development of the capacity of the judges and other workers that support the administration of justice and all. And so resources are very important. Funding is very important, and the autonomy of that funding is also important. But a situation where the judiciary would have to go cap in hand begging for resources in order to perform its own constitutional responsibility, certainly impairs on the independence of the judiciary. And where you find someone who does not respect the independence of the judiciary in the executive, then such a person will begin to manipulate the process and use the fact that I have to give you this fund for you to do what you are supposed to do to bargain with the judiciary. And that is why the judiciary has insisted that for us to function properly, don't pauperize us.
All right.
But it will seem to me that over the years, that is what has been done. To know that the judiciary, the last time that the salaries and allowances of judges and justices in this country were reviewed was in 2007.
Wow.
Notwithstanding the inflation, notwithstanding the concrete economic realities. And if it isn't to pauperize the judiciary so that you render them incapable of performing their responsibility, then I wonder what that is.
Right.
But we know that the executive has had review of their salaries. The legislature, we hear that they receive millions of naira at the end of every month, but that is not what you hear about the judiciary. Would it surprise you to know that a justice of the Supreme Court received just about 702 or 750,000 naira monthly as his salary with the workload that is in the Supreme Court? And to know that it is the judiciary, whether you like it or not, that is the truth. It is the judiciary that has kept this country together by reason of their pronouncement over the disputes that we have seen.
Yeah. All right.
Since independence.
Let me get a few more questions for you.
So there is a deliberate attempt to pauperize the judiciary over the years, and that is why the judiciary has been denied its own financial independence. But I must salute the courage of the judiciary for standing up to the situation in spite of that. And you remember the last administration came up with Executive Order number 10, and that became a subject of litigation before the Supreme Court. And the Supreme Court struck it down to say that, yes, we know that we've been denied the resources that we require to function properly, but if you have to give us resources, if you have to fund the judiciary, you have to do it properly. That is a demonstration of discipline. Even though they've been pauperized, they've been rendered incapable of performing their responsibility. But the Supreme Court demonstrated responsibility. They demonstrated discipline.
Right.
You don't just come and, as it were, maybe rub a little bit of oil on our lips with Executive Order 10 that we should be giving this amount of money, while doing so also breaches the Constitution. The Supreme Court said no. It seemed to us that this is made to benefit us, but we will simply stay with our oath to defend the Constitution of this country.
All right, go ahead.
So I thank the judiciary for doing all of that.
All right.
And remaining resolute in the performance of its own responsibility in spite of the conspiracy, I should say, to pauperize the judiciary.
All right.
Okay, sir. There's something that I see often and has bothered me, in past administrations, and I think even very recently, which is the judiciary would give an order, either bail conditions or ask someone to be released, and then we have executive agencies who seem to have superiority over the judiciary. Case in point, we have situations with DSS. Somehow DSS seem to have superiority over judiciary. And I wonder, as the MBA, how this is being addressed and whose fault is it? Is it that the judiciary itself has weakened itself because of corruption? Is it that the judiciary is not strong enough to demand that, the rule of law be followed? How are you even addressing it?
Well, let me correct the impression here. There is no institution that is above the judiciary. not the DSS, not any institution that is above the judiciary. And also, let me make the point. The most uncivilized thing that any person or any organ of government would do is to show disrespect to the orders of court. Because doing so is an invitation to chaos and to anarchy. And I want to repeat, that is the most uncivilized thing that anybody would do. But let us not forget that there are processes. There are processes. And those processes must be complied with within the ambit of what the law has provided. And for every case you see, it is important for us to have a holistic view before we can pass any assessment or judgment on the conduct of any particular agency. And so questions have been asked, particularly with respect to the issue of the DSS vis-a-vis the Emefiele matter. I know that matter is in court, even though that particular charge has been withdrawn, where the issue between the DSS and the officers of the correctional facility happened in Lagos. But let me say that none of these organs is bigger than the judiciary, and all of them are subject to the orders of the court, which must be obeyed at all times. And every single one of us, including the institutions, have a constitutional duty to comply and enforce the order of court.
Okay.
What is the NBA doing? The NBA consistently engages with these institutions to let them know that you cannot show disrespect to the processes of court, disrespect to the order of court, and expect that we would have order in the society.
Right. Okay.
Right.
Let me...
So
Sorry, because of time, we have so many questions for you, so I wanted to get a few more questions for you before you run off. There's this long-standing debate, and I'd like to hear your stand, or NBA stance on it, between the role of the Attorney General of Federation and the Minister of Justice. There's always that clash we've heard for over the years. What's the position of the NBA on this? So you're going to answer my question now. Go ahead, please.
yes, would you permit me to correct the way you pronounce that name?
Maikyau.
Maikyau.
It's
Maikyau.
Yakubu Maikyau.
Maikyau. All right. I do apologize.
Yes. No, it's all right. I mean, I get this most of the time. So you are asking about the position of the Nigerian Bar Association on the merger of the office of the Attorney General and the Minister of Justice.
Yes.
For us, it is about getting the right person in the office, someone who appreciates the responsibilities trusted on him by the Constitution to function in that particular office, completely separated from the politics that is involved. Yes, agreed. It's the president that appoints such a person into office to function, but such a person must understand that of all the ministers in the cabinet, he is one that enjoys constitutional prescription, meaning he's the only person that has been mentioned in the Constitution of the Federal Republic of Nigeria. And so such a person must bring to bear that understanding in the office and know that all that must motivate his conduct in that office is the desire to do justice. As Attorney General and then Minister, is the Chief Minister, the Chief Law Officer of the Federation, and Minister in that Temple of Justice. So for us, there is nothing wrong. It's about understanding, it's about building that institution that would function only motivated by what would bring justice to the people. And I do not see any reason why someone who is appointed Attorney General cannot also function as Minister of Justice. Because as Minister of Justice, what that reminds you constantly is that my responsibility is to justice. Yes, I've been appointed by Mr. President, but I have a duty to advise the President on the justice of a case at every particular time.
Okay. All right.
And whenever I get myself involved in any assignment, it is the justice of that matter that should motivate what I do, the advice that I give, the suggestions that I make. And let me also say that the President Bola Ahmed Tinubu, in the choice of Prince Lateef Fagbemi, did not make a mistake. That is a round peg in a round hole, someone that has conducted himself with the highest respect for standard and professionalism.
Okay, that's good.
He knows what he is expected to do in that office. And we have no doubt as a bar that Lateef Fagbemi will make this country proud in the functioning of that office as the Attorney General of the Federation.
Sir. Thank you, sir. Go ahead.
Sir, there is the question I want to ask. You know, we've been talking about how to strengthen the judiciary, and we've said it over and over again that judiciary is like holds the society together. You mentioned it yourself. We don't have, it's a last resort for common man, you know, equity, justice, all that stuff. But you mentioned one of the problems being financing the judges, and there are allegations that the big sands, the well-paid lawyers, the lawyers themselves are the clog in the wheel of getting justice for Nigerian citizens, where we have lawyers pull up cases, get this word called perpetual injunction, especially in the controversial case of former governor of Rivers State, Peter Odili, where the court has granted him immunity, blanket immunity from being able to address the corruption cases that EFCC could have brought against him. I want you to address the challenge of lawyers understanding the law and manipulating the law to the advantage of alleged criminals in Nigeria. Thank you.
So let me make this point. And perhaps I should start by saying that where there is a determination by the court, rightly or wrongly, it is only within our constitutional structure. It is only another court that is higher than the court that had made that determination that can undo what has been done. It doesn't matter who you are. It doesn't matter your standing in the profession. You do not have the right to seek to change what that court has done. You can go to the academia and do a scholastic examination of that thing that the court has done. But it is not within my remit to look at the decision of the court and say that the decision is wrong or right. But again, I agree with you that there has been the problem of the understanding of the true ideal of the members of the legal profession. And what is this true ideal? The clergy, the profession of the clergy, the political profession, and the legal profession were three professions for which no money was paid for those who practice that profession. And so for the legal profession, it was Sir Shakpara Williams that aptly captured the true ideal of a legal practitioner. And he said that the legal practitioner lives for the direction of his people and the advancement of the cause of his country. And that was why initially lawyers don't receive fees. And that is also the reason why the profession was only meant for the aristocrats. But that has certainly changed. The profession has been commercialized, but the true ideals of that profession can still be maintained if members of the legal profession remain fixated on the need to serve justice. We are agents to the person of justice, And it is when we fix our gaze, when we set our eyes and focus on the attainment of justice, that we would ensure that no matter what we are paid, it is not going to be the motivation for what we do. So, to that extent, I would say that for those that we find who misconduct themselves in the process of representing their clients, it is because they have lost focus on the true ideal for which they are called to live, that is, to give direction to the people and the advancement for the cause of this nation. So, I know that there are complaints here and there about lawyers who misconduct themselves, and I know that there are some of them who do misconduct themselves in the conduct of the cases for their clients. We can see that, we receive complaints, and that we always forward to the Legal Practitioners Disciplinary Committee to deal with it. And I just want to say that as Nigerian Bar Association, we would not close our eyes to any case of professional misconduct reported to us.
Right.
If it is a misconduct that is reported against a judge, we would make sure that we follow up with the National Judicial Council, that is the constitutional body set up to deal with issues of discipline for judges. And if it is for lawyers, we would go to the Legal Practitioners Disciplinary Committee. And for one who is also a senior advocate of Nigeria, the Legal Practitioners Privileges Committee is there. Number one, such a person, if found wanting, can be stripped of his rank as senior advocate of Nigeria. And the LPDC, which is the Legal Practitioners Disciplinary Committee, if he is also found wanting in the determination of any allegation against the counsel, the appropriate punishment will be meted on the counsel. And we are committed to that. This administration is known for zero tolerance for professional misconduct.
Right.
Okay. So let's get your thoughts on the alleged attempts to bribe the chairperson of the Election Petitions Tribunal in Kano, Floral Azenge, in relation to so many accusations against lawyers that try to induce judgments in favor of their clients. So how many lawyers have been prosecuted in relation to bribery and corruption charges? What does the NBA Constitution say about this? And what is the association doing to ensure that these rules are being adhered to?
So, number one, it is professional misconduct for anybody to try to compromise any judge. It is not about the NBA Constitution. It is also a crime for you to attempt to do that. And that is why, as the president of the bar, I have repeatedly said in different fora, if you have any allegation against any judge, please do well to give us the information and we will take it up. Similarly, with respect to this allegation against a lawyer or lawyers who attempted to bribe the judge at the tribunal in Kano, I directed the chairman of the NBA branch in Kano to write to the judge. If you said someone who is also a senior advocate of Nigeria attempted to bribe you, that judge must know that any attempt to cover up that particular lawyer is also professional misconduct in itself. That means the judge who refuses to give information about the lawyer who attempted to bribe the judge is also colluding to pervert the course of justice. So we have requested for the information. That is the cooperation that we need from the bench. If anyone approaches the bench to seek to compromise the bench, let us have that information about that lawyer. And I say the same thing for those who lay accusations against judges. If any judge approaches you and asks you to give him money or do one thing in exchange for judgment, a favorable judgment, let us know. Make that evidence available. That is the least that any lawyer or any judge would do in the help against the fight against corruption.
Right.
So that is my thought on it. We have written, we are expecting that that information is going to be made available to us, and you can be rest assured that whoever that counsel is, if we have that information, we will file a complaint against that lawyer before the Legal Practitioners Disciplinary Committee.
All right.
And we have no doubt that if that allegation is proven, the appropriate punishment will be meted on the lawyer.
Right.
So this question, I feel like you've answered it in responses to many other questions before. But I would just like to know maybe a few you just list out. What are the reforms you would like to see that the new Minister of Justice and Attorney General work on? Like, what is it that the MBA would like to see differently? What are the reforms you're looking forward to? Just maybe give us like 3 that, you know, expect.
Well, now that affords me the opportunity to talk about the upcoming conference of the Nigerian Bar Association, the annual general conference of the Nigerian Bar Association. And the theme of the conference is getting it right, charting a course for Nigeria's nation building. And we have a session that is curated with the Attorney General of the Federation on justice reform, the agenda for the reform of the justice sector in Nigeria. We want to see a holistic reform in the entire justice sector in this country, be it the prosecuting agencies. We need to see a situation where the person who is investigating the offense is not the same person who is prosecuting the offense. The Honorable Attorney General, in his screening before the Senate, did mention that, and that is a welcome development for us as a bar, because that is something that must be done. The issue of correctional facility, the prison, there ought to be prison reform. And in the forefront of all of this is the judicial, the salaries and allowances of judicial officers. In fact, that is a matter of emergency in this country, that a justice of the Supreme Court, it is shameful to even mention it, with all the responsibilities that have been trusted on them, receive 750,000 naira every month. That is what we've been paying them. And there is no judicial officer in this country that has had his salaries and allowances reviewed since 2007. Then it is pathetic. It is pathetic. It is almost fraudulent to expect the judiciary to perform its responsibility with the way it's been neglected. So these are the kind of reforms that we are looking at. Put the judiciary in a place where it would only be justice-focused. The decisions that would come out of the courts would be decisions that would be reflective of the justice of every situation. And then those that are given responsibilities to do one thing or the other in the justice administration in this country are properly taken care of, so that they also would not be distracted. They would focus on the need for them to do what they are supposed to do, only to satisfy the demand of justice. And I said to the Honorable Attorney General that the Nigerian Bar Association would support him because we know who he is, we know what he represents. The bar is happy, we are proud, and we are there to support him through the justice reform agenda that he's coming on board with in order to make sure that the entire system is overhauled. And that is why we were deliberate in curating this session, where the Attorney General would have interaction with other members of the executive and legislature. We've invited the Senate President, some governors that are lawyers, to come and discuss that justice, the reform in the justice sector in this country. Because only then can we continue to have prosperity in this country. Our economy is dependent on the kind of justice that we have in this country. And of
Okay. Sir, can you hear me? Oh, I want to be sure he's still there. Hello, sir. Are you there? All right. So
Yes, I'm here.
Let me get to just two questions in one so that we wrap up very quickly. I've heard about the watered-down judgments given by judges in recent times. I've attended a few of these conferences where a lot of lawyers have complained that back in the day, you know, when you read a judgment, you understand clearly the decision, the thought that went behind every case. But these days, the judgments seem a bit watered down. What are we doing to get maybe more quality judges, I would say, or maybe more quality judgment from these our judges? That's one. The second question I was going to ask was a very disheartening observation that out of the 685 SANs in our country, only 29 are women. So 4%, I think it's 4.2% of the lawyers who are senior advocates of Nigeria since 1975 are women. Only 29.
Terrible.
That's quite disheartening.
Terrible.
What are you doing, or what do you plan to do or are you saying that there are no women who are deserving of the role of SAN or the award or the honor of SAN? That's two questions in one.
Yes, so thank you very much. And that is a very important question, something that is very close to my heart as a person, and also someone who privileged to be the president of the bar at this time. By the special grace of God, where we have started doing something in that respect. Okay. But you must also understand that the rank of the senior advocate is not given as an appointment.
It's earned.
It is something for which you have to work for, satisfy certain requirements, and then you apply. And to a large extent, I would say it has to do with the number of applications that have been submitted by our female colleagues. But again, the male folks in the profession must be deliberate in encouraging our female colleagues in satisfying the requirements and applying. And we must also not forget the fact that in our African setting, and Nigeria is not different, we have certain cultural and maybe religious restrictions or limitations that have been responsible for the low applications that we see, because for you it is quite a huge task satisfying that requirement, doing cases in all the tiers of the court, from the High Court to the Supreme Court. So building a career in the legal profession that puts you on that trajectory to go to the peak of the profession as a senior advocate has been quite challenging for our female colleagues. You find someone who has to combine dealing with not only the husband, the children at home, and combining it with the demand of building that career. But what are we doing? We're encouraging our colleagues. I mean, I don't want to, I would leave it for some of our colleagues that I know we have been talking on this and what we have done to encourage them, and we are doing that. And in no time, by the special grace of God, I know we've sown that seed that would guarantee.
Unfortunately, we've run out of time.
Now,
I would have loved for you to
let me just say very quickly about watered down judgments. I don't know who makes that decision. We are concerned really about the appointment of justice. The appointment of judges has to be merit-based and all of that. But you see, when lawyers come on television and begin to talk about watered down judgments, it also smacks of professional misconduct. Because most of these lawyers that I see come to talk to you on television, if you ask them, and I've witnessed certain interviews with some of our colleagues, even senior colleagues at that, who would come and begin to talk about judgments, castigate not just the judgment, but the justices that have written that judgment, even before reading the judgment. That is highly irresponsible. How do you talk about something you haven't read? And in most cases, we hide under this narrative that we have sold to the public that the judiciary is corrupt. So we lawyers because we are also not held professionally negligent when we misconduct ourselves in the conduct of our cases, it becomes very convenient, even when we fail to do what we are supposed to do as lawyers, to simply say, well, you know, what happens now, the judge has been compromised, that is why the judgment turned out this way. We should interrogate what the lawyers have presented before the court. And it is what we have presented that the judges have to work on. Of course, we know instances where some of the judges, the superior courts have made comments about some of the judges to say that some of them are not even fit to be judges. But it takes two to tango.
Okay.
We have to do what we are supposed to do as lawyers before we get something that we expect.
Okay.
Thank you, sir.
Thank you so much, sir. I'm so sorry we had to cut it off because time has run out, but I do appreciate your being here. Thank you so much for joining us this morning. That's all we can take on today's show. Have a great day. We'll see you tomorrow. Bye for now.